Well, good afternoon, and whether you're in the office or working from home or working from somewhere, thanks for joining us again. Lewis, as always, delightful to have you with me.
Delightful to be here.
We had quite a bit of. I'm nervous today because I think we might have too much content, but we're going to kind of see how best we can go because we had quite a bit of feedback last time we did this about what to focus on. We're going to talk a little bit about sort of the planning and the structuring side, a little bit of the sort of employment types, a bit happening in the independent contractor world at the moment, some fun stuff. And if we get a chance, we're going to talk about the future of work, and I think at the very least, probably have to talk about the current debate about in the office at home. Might touch on some more futuristic issues as well if we have time. And unashamedly, if you sort of cut today into pieces, I think we're sort of talking more about the HR stuff to begin with, and you're very delightfully going to let me lead through that.
Yep, absolutely.
We'll get on to more of the sort of legally stuff, and then we'll talk about the future. So hopefully we'll kind of touch on most things that need to be touched on in terms of sort of workforce planning. I think when you hear the word workforce planning, it actually sort of almost means so many different things to different people. I tend to sort of put it into four boxes. It's about how do you structure the organisation in terms of the operating model and the labour force. It's about the actual composition of that workforce. And then you've got what we might call far more the sort of traditional HR senses of workforce planning, talent and succession. And then, as quite a few people do these days, they have particular ways of addressing key challenges in their workforce. And we've identified a couple there, which probably are fairly familiar. You know, we often have clients come to us and say, I've got disproportionate turnover in a particular part. What's the solution? It's taking me longer to recruit now than it's ever done before. What's the solution? So there's quite a bit to talk about. To be frank, we just don't have time to deal with it all. And I wouldn't mind just concentrating on the first two boxes, just to try and give a general sense of how we might advise people in those first two boxes, be they small, medium, or, as often is the case, very large. I thought we'd just sort of try and break down the mystique, and I'm sure everybody who's studied organisational design is going to be very upset by how simple I'm going to try and describe this. But in terms of organisational design, when you're designing a structure, I normally would ask a client to think of it, first of all, on the left-hand side and then the right-hand side. And if you think about what's on the left-hand side, we always start with a business model. And if you've never done business model canvas mapping, give me a call and we'll point you in the right direction for that. But it's an essential thing to understand that your workforce, which effectively gives effect to your operating model, comes from that business model. And I normally, when we're talking to clients, we want to talk about three things, and that is those parts of the business which interact and face the customer, where the customer experience is critical. We then talk about what we often describe as the doers and makers, and the primary drivers there when we talk to clients are cost, quality and actual output. And then support functions, where the primary drivers are compliance and principally efficiency of delivery. And so I'd invite everybody, whenever you're thinking about the structure of your workforce or the restructuring of your workforce, proposition number one would be start by the thought of those three boxes, building off the business model. The part of the right-hand side is a really important part because that's really about sourcing of labour. And it sometimes gets less time than it deserves. And that is, what is the optimum sourcing model for labour in your business? And that's going to be driven by things like cost. It's going to be driven by things like your culture. It's also going to be driven things such as your scale, internal capability versus external expertise and the like. But it's a really important element to always have a conversation around sourcing. So when you start this, I would say to everybody, be you small, medium or large, start by thinking around those propositions to get going.
And I take it, Nigel, that when you look at those three types of boxes, you know, customer experience, customer facing versus people who are doing and making whatever it is your undertaking is versus then the support. It might be that employees are critical to one element. It might be the customer experience because they're completely aligned to the culture and the way you present yourself. Whereas contractors or labour hire might be efficient for other parts, whether that be support
Yeah.
or even doing and making. There might be elements of the doing and making that aren't your core competency or capability, and you might need, you might think it's easier to have contractors for that part. It could be completely the other way around. It might be the customer experience is quite a vanilla, transactional thing that doesn't need employees, and actually the critical element of your business model is the making of a particular product. That's where the IP is and the know-how, and that's where the employees are. So I take it the different categories will fit with the different boxes depending about how pivotal they are to your organisation.
Yeah, and it's that textured nature of conversation that I encourage everybody to have, rather than just think the stuff on the right-hand side of the screen is just about cost or something like that, or industrial relations. It needs to be exactly the way you've described. Now, when we go into businesses, and it's a bit of a best-kept secret that we do go into businesses sometimes and help them restructure, I tend to encourage people to always do what I call an activity-based analysis, and most people are quite capable of doing this. One normally does an activity-based analysis by an interview process of actually interviewing key stakeholders in the part of the business you're analysing. And what you're normally trying to find out is exactly what people do, exactly what the frequency of that activity is, what the outcomes they're trying to achieve, and more importantly, what value that those activities are creating for the business in the context of those boxes we talked about earlier. We would normally make findings based on that type of review, and then we'd make recommendations. And I've just, at this stage on the right-hand side, just put a couple of little sort of touchstones. If you're doing any analysis about changing structure, I'd probably say that there's three things you want to concentrate on more than anything else. Work, product and activity is critical. I often hear people say, well, we're going to reduce the number of people in this area without even understanding what they do. And later on they come back and go, something's now missing in my business. Management ratios is really important. You really have to work out whether or not you're going to end up with indulgent supervisory or management ratios or more effective. And typically speaking, 1 to 8 in a normal business is about right. So 1 supervisor to 8 people is about right. If you've got a transactional business like a call centre, you often get ratios like 1 to 20. But look very carefully at your management ratios. And the third point I'd say, which is critical, is always delegation. It's always important that the different layers of an organisation understand what they have the authority to do and not do. And very importantly, to make sure that that doesn't overlap to create confusion. And my bugbear in all of this is what I put down at the bottom, is you often do an analysis and you find that there are certain jobs that just don't add any value. And those are the ones I normally try and say, does the organisation need them? And you'll see sometimes people will actually not only not add value to things they touch, you often see certain jobs actually create activity for others that doesn't add value. But this notion of an activity-based analysis is a much better way of working out what you need, rather than sitting down on the back of a beer mat going, I think this structure looks good, what do you think? And that's what I'd encourage all of our viewers to think about. There's probably 2 areas that I and this is probably getting on to where you were, think in terms of your functional activity, be it finance, marketing, communications, HR, whatever it might be, think long and hard about what you can create in your business that's truly efficient for your business. Most small businesses, it's sensible to outsource most of these things, and you can probably outsource it quite efficiently. If you're a large business, you might be trying to drive what we call a centre of excellence. Just be very mindful that it's actually hard to maintain a small centre of excellence, because it becomes very key person dependent. And more often than not, if you're driving a centre of excellence, you really need scale. And we've got a few clients who do that, particularly in the legal space or the HR space or something like that. But just have a think about how you're actually setting up that back office function for your business and what is the most efficient. It's a really critical issue. And probably the last thing,
just on that last slide, that when you talk about a centre of excellence versus outsourced, it really also depends about how bespoke your business is or wants to be. Because if you are requiring run-of-the-mill or relatively standard
services,
you're more in the middle or outsourced, in the sense that, well, I can probably get someone who does this all the time and can help me out. But if you actually think, no, what we need is something quite specific or peculiar to us,
with very particular knowledge,
that's when you're more in the, do we become self-sufficient in this area?
Yeah, absolutely. And probably the one thing that I would say is be mindful that there's a control element here as well. The more you outsource,
Yes.
more often not, the less control you might have. The more you insource, the more control you might have. But I'm always nervous about back offices because back offices get very big very quickly, which leads me very nicely onto my last little point, which is when you come to think about the functions in your business that are actually servicing the front of the business, just be very mindful about, are you trying to just go skinny and get by? Or have you actually started to become quite indulgent? And I'll give you a simple example. We've got a client who's in the technology world. They've grown exponentially. In the last, I think, 3 years, they've gone from 50 people to 350. And they've been quite surprised how large their back office has got proportional to actually the revenue and the profit they're generating. And it's because they haven't really sat down and thought about what they need and what's the most efficient way to provide it. They've just allowed themselves to grow and add and add and add. So particularly for those people who are growing, in terms of that back office function, are you more get by? And if so, what does that look like? Or are you more indulgent? Perhaps you've got a very different risk profile, and those are the things to consider in that area. So just generally speaking, before we get on to some of the more technical stuff, if you're thinking about, is my structure right? Am I going to restructure? I'd encourage everybody to think about those sort of key areas I've gone through and using an activity-based analysis as best they can. Be you small, medium or big. I think there's probably some insights in there that will probably help everybody get a better outcome if they go through that process. Now, let's swing round then to just the restructure process. We'll finish off there. If you think about the two areas of vulnerability we see a lot when people are restructuring, it's around that engagement box. Now, you would appreciate that normally introduces legal obligations around consultation.
Yeah, so I think when you are starting to go on the journey with your own workforce about
change,
where you're going to end up or change, you have to bear in mind there's both HR and legal consequences. On both sides, from an HR perspective, of course, you need to interact with them, you need to engage with them about what's happening. Otherwise, they won't come with you on the journey. You lead to disengagement, dissatisfaction. On the legal side, that's kind of built in when we talk about consultation obligations. So under an enterprise agreement or under modern awards, when you are implementing major changes to the structural workforce, its composition, technology, that's going to have a significant effect on employees, there are very rigid requirements imposed by both modern awards and
enterprise agreements and some contracts that we read.
And indeed some contracts to actually meet with people, to provide them certain types of information in writing, give them an opportunity to respond, to engage with their representatives. So all of these types of obligations are triggered, and they're all triggered the moment you've made a definite decision to go down a particular path. So you need to ensure that you engage at the right time in relation to these consultation obligations so that you don't expose yourself from a legal liability perspective. And
I'll probably add two things to that. One is about definite decision. Most people, if you're covered by a modern award, that will be the trigger. If you cover by an enterprise agreement, I beg you to reread your enterprise agreement before you start making any major changes in your business. We sometimes have clients who realise that they've put some other definition in, and that might actually trigger an obligation to consult way before definite decision. We've seen some agreements in the tertiary sector. I've made the joke before that if the CEO was in the shower in the morning having an idea about a new structure, he's got to ring the union and consult. So just be very careful if you do have an enterprise agreement. Just make sure it is definite decision that triggers that obligation. And the other thing I'd say about it, when you're in that engagement phase, if you are restructuring your business, just be mindful of one very simple proposition. The minute you stop communicating, you create a vacuum, and something or somebody will fill that communication vacuum, and that's normally where gossip and rumours get in. So the fundamental issue is meet your legal obligations, but also from a cultural perspective, over-communicate rather than under-communicate. The other area which I think is really, really important, and you and I talk about this quite a bit sometimes, is the implementation and bedding down. It's sometimes the case that businesses will change their business structure and their workforce structure, and they get the kind of homework part at the back end not as good as it could be. What do I mean by that? Well, are you issuing the right new contracts for the right new roles? Have you actually given somebody a position description for their new job? If there's performance measures to meet in the new job, performance outcomes, do they actually know what they are? If their delegation has changed, have you told them what their new delegation is? So just be mindful that there's quite a bit of work down that back end, which again is that nice blend between the legal and the human resource management. If you follow that process as effectively as we've described, and you do that planning, you do that review piece using activity-based analysis, I think that's probably, unless we spend a whole day with you, it's probably the best advice we're going to be able to give you. Now let's turn our minds then, Lewis, to who might we use, and I'm going to start with full-time, aren't we?
Yeah, so I think when you come to talking about the types of workers you're going to use in your business, I think you need to bear in mind that there are actually a variety of options open to you. You've got full-timers, part-timers, casual employees, contractors,
fixed term,
maximum employees. Term. So you've got all of these different types of workers, I should say, that you can leverage off, and some will work best in certain circumstances, others will be suited to other circumstances. So we're going to go through each of them. If we start with full-time employees, the critical feature of a full-timer is that they are usually, under most awards, engaged for a full load of 38 hours a week on average. And that'll be averaged over a particular cycle. If someone's award-free, you can average their hours over up to 6 months under the Fair Work Act. But if they're under an award, it'll depend on what the award says. Some allow 4 weeks, some allow 12 weeks, 8 weeks. There's a variety of different averaging cycles permitted in different industries. So the full-timers, you're committing to a full load of hours a week, but really interestingly, you're not committing, particularly under the award, to when those hours are worked. So in your contract, you might make certain commitments, but the awards aren't particularly fussed with that. The awards are more fussed with, if you've got a full-timer, they have to work an average of 38. But you could actually implement rostering arrangements that allow for a level of fluctuation as to when the hours are worked, if there is a desire to have your labour meet varying demand for their services. So whilst it sounds rigid in some senses, i.e. you have to give them a full load, there's a bit of flexibility about when they work it, provided you also ensure your contracts allow for that. The big issue with full-timers you need to bear in mind, though, is it's 38 hours a week. So if you don't have that workload for them at any time, you can't just not pay them. You can't just say there's only 15 hours worth of work. You're going to have to pay the full load each week. And so you're committing to a level of work, but not necessarily when it's performed. That's the full-time picture.
And probably the one thing I do want to just maybe add in that is we often see a lot of employers write their employment contracts which constrain what they could otherwise have done under a modern award or even an enterprise agreement. And so just don't loosely write stuff about working week, when they start, when they finish, because inadvertently sometimes you end up constraining the flexibility you might have had under a modern award. So that's probably the thing I would say when you are employing full-time people, just watch out for that issue.
Yeah, agreed. So that's obviously a very common form of engagement. We then have part-time. Now, part-time's got a lot of different barnacles on it in a way. The first element of part-time, it is much, much more inflexible for any award-covered workers. And the reason that it is more inflexible is that most awards contain extraordinarily prescriptive provisions about when the hours are to be worked. Starting times, finishing times. In a number of awards, they prescribe when the meal break is to be taken. I mean, if you just think about that, it's somewhat interesting in this day and age that you agree on a regime of work for a part-timer, and at the beginning of that relationship, you have to contractually agree on when the meal break will be each and every day, and then it is set in stone and cannot be varied except by agreement. So there's quite a high level of prescriptiveness required under the awards. And the hours, once fixed, generally can only be changed by mutual agreement in writing. The consequence of that is if you are going to then try and have a part-timer work additional hours, those additional hours under many awards will attract overtime payments because they are hours beyond their usual ordinary hours per week. And the only way you can get around that is to actually agree to vary the part-timer's regular pattern of work for a particular week. So literally going to a part-timer and saying, I know you usually work Monday, Wednesday, Friday, 9 to 5. For this week, can we vary your regular pattern of work to Tuesday, Thursday? And then at the end of the week, we're going to vary it back to Monday, Wednesday, Friday. If you do that and you set that up in writing, you might not have overtime commitments, but otherwise you will. And so whilst you don't have to offer a 38-hour weekly load, you're far more constrained into effectively honouring the hours that you promise up front.
And it's one of those areas where I think you really do need to make sure you've read your reward if they're reward covered. Because as Lewis said, some of the formulations are sort of you have to work a certain number of hours in a week. They say no more. Others are down to days in the week when on those days. So that's proposition, I think, number one. And it's probably a challenge because most of the people, even in our business who work part-time, there's an inherent sense of flexibility that we've got. If you say to a lot of people who work part-time, in my experience, can you do Thursday afternoon for me to fill in? They go, yes. You don't automatically go, am I obliged to pay that person overtime, or do I have to now write a new agreement saying you're going to work Thursday? So particularly when we do payroll audits, this is an area where you see a lot of technical non-compliance.
Absolutely.
People just need to be aware of it.
Yeah, absolutely. And I think I suppose two final things on this. One, just like with full-timers, you can't just unilaterally reduce the hours as well. So you have to honour the minimum hours you've committed to each week. But there are changes afoot. And I think those changes...
He's running. Have you finished running your case?
No, we're still going. So those changes are in two formats. In the restaurant and hospitality industries, a new form of flexibility has already arisen. So in those, if you're a hospitality employer or a restaurant or a restaurateur, under those awards, the part-time provisions allow you to offer a minimum floor of hours, which I think is set at 8, and there's a guaranteed level of hours. And then you can actually offer additional hours each week, depending on the availability that the employee has indicated. And there is actually this ability to flex up hours each week, which is obviously well suited to those types of industries that have very fluctuating demand for service. But we're now seeking to extend that a bit more broadly. In the general retail industry, our firm's acting for Business New South Wales and ABI. And what we're doing is seeking to create a much more flexible and much more practical mechanism to enable employers and employees to allocate additional hours or to vary hours of work with quite simple mechanisms. Now, we're hoping it can be something as simple as a text message. There's current proceedings on foot where we are at points furiously in disagreement with the SDA, the ACTU. There's points where we appear to be furiously in agreement, but perhaps unable to recognise it. There's all sorts of kind of push and pull levers at the moment in the proceedings. But what we are hopeful is that at the end of these proceedings that are on foot as we speak, there will be a mechanism in place that allows for additional hours to be offered to part-timers a little bit more flexibly than is currently the case.
I think the three important takeaways of that is you assume straight away that part-time employment is inherently flexible. Read the award very carefully if they're covered by an award, because it might not be quite as flexible. That's undoubtedly proposition number one. I suspect this will be a tug-of-war area with the ACTU certainly over the next 2 or 3 years, because their narrative's about insecurity of employment. Our narrative is about flexibility, so it's going to be an area where there's going to be ongoing contest. Probably the third thing I'd say to most people is, where you're award-free, again, be very careful how you write provisions for part-time employees. You might end up tying yourselves in knots in putting lots of detail into that employment contract, which you really don't need to do. So they're probably the three takeaways I'd have around part-time. But I suspect if you look at the data, still on the increase.
Yes, absolutely. As we see, particularly carers entering the workforce.
And people winding down in their careers at the back end, moving to 4 days, 3 days a week. There's no doubt that it will continue to probably be on the rise as a form of employment in Australia.
No doubt. Now we move
Your
to
favourite topic.
your
favourite topic.
The third and final form of permanent engagement, in a sense, is fixed-term employment, and fixed-term employment is a very it's a tortured term in some senses, or a difficult one, because we need to be very clear about what we're talking about. So a fixed-term commitment to an employee may, on the one hand, be very much rigid and locked in concrete, that you're going to employ someone for a particular period.
So this is a contract which operates for 12 months and expires on the 7th of July 2022.
Absolutely. So it's got a specified end date, or it's for a specific task or period. So it might not always be time limited. It might be for the summer fruit picking season. It might be for a harvest. It might be for a particular task to get a project done. But what the contract does not allow for is early termination, save for serious misconduct. Now, that's what we often call a true fixed term contract. And those fixed term contracts are very rarely used. We very rarely see employers use them. The main reason for that is if you do want to terminate early, you have to pay out the balance of the contract.
Let's say it's a 12-month contract. It's effectively guaranteed, unless there is serious misconduct, that you will get the value of that contract.
That's right. And if we start talking about 2 or 3 year contracts, which we often see in the medical, we've got a lot of medical research clients, and that's not uncommon to see 3 or 4 year contracts. If you want to terminate early, 1 year in, that's a big payment.
If it's a true fixed term
contract, absolutely. So that is the first category of contract. The one particular advantage of that contract is that if you terminate at the end of the contract, there is no access to unfair dismissal laws, because the unfair dismissal laws carve out those types of contracts, and there's no access to redundancy pay, things like that, or notice of termination. Now, the much more common form of engagement is what we call a max term contract, or maximum term contract. And in those contracts, you still have a specified project or a period.
So I've got all of the ingredients of the fixed term, but I have more.
But you have the ability to terminate earlier on notice. So generally in these contracts, employer or employee can still terminate with 4 weeks notice or a sliding scale of notice. Those contracts tend to be the ones that employers like to use, because if they do need to pull the parachute
get out of jail,
they can. The thing you need to bear in mind is, if you do get out of jail, or if you do need to see,
you might go to jail.
Right. I don't know if that's right. So, but if you do seek to exercise that lever or pull that trigger, you don't have an exemption from unfair dismissal laws. So yes, you don't have to pay out the balance of a contract, but for unfair dismissal covered workers, you need to ensure the appropriate process is in place. You have a valid reason for dismissal, all those types of things. If you terminate the contract at the end of its life,
this is maximum term?
A maximum term, that is when you get into a very grey bucket as to whether there is unfair dismissal or there isn't, whether there are redundancy liability or not, whether there is notice of termination or there's not. And we won't bore you with all the details today. I shouldn't say bore, because for some of us, it's quite interesting.
So I think the general proposition is that if this is your first and only maximum term, you might be on a better footing.
Yes.
If it's your 7th in a row, you're probably at a
general level, probably right. But they really look at, is there a very clear commitment from both sides that the intent was for the whole relationship to end?
Or is it ongoing?
Or is meant to be ongoing? And they'll look at all the other factors. But I think the takeout for today is you need to accept that with max term contracts, even if you let it expire at the end of its life, if it's a second or subsequent contract, there might still be risk of these unfair dismissal type exposures. So whichever contract you use, when we're talking about workforce structure, where these types of contracts become invaluable is where you do want to engage someone for a particular period that you know is finite. You know you don't need them forever. You're not going to want to use full-time. You're not going to want to use part-time. You don't have to engage them as casual. You can actually use this other form of engagement, which is quite common and which has a level of definitiveness about the hours of work during the life of the contract, but also its end date.
And I think the simple fact is, be aware there are these two distinctions.
Yes.
And have your eyes open about which one you're choosing.
Yep.
Yeah.
And just, we've got one question I'll quickly answer. Can we terminate a fixed term contract in the probation period? Well, that's the classic question of which contract we're talking about. If you've got a probationary period, it's not a fixed term contract. It's allowing early termination. So it's not a true fixed term. It would fall into the max term category.
Let me ask the question in a different way then, rather than probation period. Does the 6-month or 12-month qualification period for unfair dismissal still apply?
Yes, it does. So someone does not have unfair dismissal rights in the first 6 months.
That's different to paying out the contract issue.
That's right. But if you actually have an ability to terminate early, it's not a true fixed term.
It's one of them on the right.
Yeah, exactly.
That's a good question. That's a good question.
Finally,
your favourite topic. Your favourite topic at the moment.
Casual employment it's become a lot simpler. And casual employment...
We might disagree on that, but that's...
Casual employment has been used regularly by a large number of employers. Nigel will tell you the usage of casuals has remained static for the last decade.
Since 2017.
2017.
So I ran the test case, sorry.
Okay, so but it has remained...
Even though the ACT tells you it's constantly on the rise?
It's actually been static for some time. And it's about 20%, 21, 22% of the workforce. The interesting thing is of about half of those casuals are actually engaged quite regularly and systematically. They've engaged for kind of more than 6 months with the same hours week in, week out. And there was a real question mark over whether these people were genuinely casuals.
Yeah.
And there were a number of cases over the last few years, predominantly involving WorkPack, challenging the status of these employees.
Which we've talked about on webcasts in the past.
Absolutely. I think the short position is this. Since March this year, there's been a new provision introduced into the Fair Work Act that, provided you pull certain levers, give you a significantly greater degree of certainty over the status of the casual's employment. And that is Section 15A of the Fair Work Act. And what it says is that a person is a casual if an offer of employment is made on the basis that the employer is giving no firm advance commitment to continuing an indefinite work, as you'll see up on the slide, that person has accepted the offer on that basis, and the person is accordingly an employee as a result of that acceptance. So if there's this offer with no firm advance commitment to continuing indefinite work according to an agreed pattern, and the person accepts that offer, and as a result they're an employee, they are a casual. Now, the Act then goes on to say, in determining what is a firm advance commitment, only a select number of things can be looked at. And they are those 4 factors identified on the slide. Can the employer elect to offer work, and the employee can elect to accept or reject it?
Which is, I'm a cafe and I'm saying, do you want the Saturday shift or not?
And the employee always has a right to say, yes, I can or can't do it. Whether the person will work as required according to the needs of the employer. Now, I'm going to come back to that one because I'm not too sure what it means, but we'll come back to that. Whether the employment is described as casual employment, that's a very easy box to tick. And whether the person's entitled to a casual loading, generally, under the terms of the offer of Fair Work instrument. Now, if we put aside subclause B for a moment, the first 3 are pretty easy to check the box. Generally, you call your casuals a casual. Almost always they're paid 25% loading. It might not be called out, so you need to make sure you call it out.
It'd be smarter in future to do that.
And you need to ensure it's clear that you can elect to offer work according to your needs, or the employee can elect to accept or reject. If you tick those 3 boxes, then it is a very good chance that your employee, no matter how regularly they work, will be a casual. The element as to whether someone's going to work as required according to the needs of the employer, I don't understand that, because I would have thought most permanent employees...
Everybody does that.
...works as required. Who works if it's not required? I mean, particularly with some of our more industrial clients, I can tell you the employers do not work if it's not required. There's still a number of industries where permanent workers will only do absolutely what is required and nothing more. So this notion that permanents don't, or that the casuals need to work according to the needs of the employer, I would have thought that applies to all employees. So it's going to be interesting to see how the courts give that some actual meaning.
Let me hit you with the questions that I think are rolling in to our business on a regular basis at the moment. One, the debate now is more about how the employment contract's been structured with this person, how it's been entered into.
Yes.
It's not about what happened 5 years later and how they're actually working. That's proposition number one.
Yes.
Yep.
Much more form over substance.
Over substance, and I don't think people are quite grasping that. Number two, I think a lot of people are saying to us, do I need to issue new contracts? What's your view about that?
I think the short answer is going to be yes.
Yes.
Because unless your contract ticked off each of those specific matters, it probably is going to have some improvements that can be given to it to really lock you into that 15A casual definition.
Now, the third thing is that as we speak, we're heavily involved on behalf of the Australian Chamber in, I'm not sure if I'm going to get this right, aligning all this to what's in the awards. Now, I'll be honest, I haven't kept up with where that is in the last 2 weeks. Have you?
Well, I can tell you that, one of our lawyers, Julian Arndt, is feverishly
working on that.
But long story short, the awards are being redrafted to ensure they align with that definition. So I can't profess to tell you exactly what they will look like.
Because it hasn't happened yet.
Because it hasn't happened yet. But the award definitions will change, and I suspect they'll look a lot more like what we're seeing up on the slide right now.
And the only other thing I would say is, look, we'll keep you posted on when those changes happen. But it will also be important to just double check those awards to make sure there's not some industry nuance that's also there or has continued to operate. Because in some industries there is some nuance about not this, but when you can use a casual, and you need to be very, very mindful of that. You've taken a complex matter and tried to make it as simple as we can make it. But I think the real ticket here is that if you employ a lot of casuals, I'd pick the phone up and talk to us.
Contracts.
So we can talk to you about how we update the contracts for you and put you in a much more low-risk environment than possibly might have been the case 18 months ago.
Yep, agreed. So we've gone through all the employee categories that you might use in your business. And I think just before we move on to the other category of worker, you really need to be thinking about the mix that works. So not everyone's going to be permanent, because in many businesses that might not allow you to flex up or down in accordance with variation in demand. So you're probably looking at the right mix of permanent, fixed term in some circumstances, and casual, to ensure that when there is an influx of work, you can leverage up quickly.
And the alternative to that might be you might be accessing a labour hire firm to replace your casuals or something like that as an alternative.
Agreed.
If that's commercially appropriate to do so.
That's right. And then there's this other breed of worker, the independent contractor. And
which is an entirely settled area, Lewis?
No, one thought it was.
We thought it was.
It's an area that is under considerable scrutiny at the moment. There is a decision that many practitioners will have heard of. It's the seminal decision in this area, and it's called Hollis and Varbu, and it dates back to 2001. And
it was a good decision.
It was a good decision. and the High Court decision effectively said that what you need to work out is the person working as an entrepreneur who owns and operates their own business, or are they performing work in someone else's business that isn't their own? And if the answer is yes, they're performing the work as an entrepreneur in their own business, they're an independent contractor. If they're not, they're likely to be an employee. That was the essence of Hollis and Varbu. It has been subsequently referred to and summarised in subsequent cases, and you'll see the quote up on the slide is from a 2011 federal court case. Unfortunately, for various reasons, again, it's inappropriate to use the word bore because for some it might be interesting, but over time, the federal court has kept summarising and paraphrasing and reparaphrasing those comments and has ended up in a little bit of a twisted knot. And the reason it has is that it started with this simple concept that just because, if we take you back to this slide, in Hollis and Varbu, the High Court said, just because you're an entrepreneur working for your own business, that doesn't mean other businesses can't benefit from that. Naturally, that seems to be an uncontroversial proposition. If I run a business and I'm trying to sell my wares, I'm sure other businesses will benefit from it. That's kind of been paraphrased over and over again to the point that the federal court got to a relatively contorted position in a case called Morrow and Tatspet, where they said you can be working in your own business but simultaneously working in the other business, which all of a sudden seems a bit odd that you're working in your business but that work is also simultaneously work in that other business. And so this kind of sense of whispering along the chain of judgments has ended up in a bit of a contortion, and it all has finally unraveled in some sense in two very conflicting decisions: CFMMEU v personnel contracting and JAMSEC and ZG operations. Now in CFMMEU and personnel contracting, we had a 22-year-old backpacker working in the construction industry. The court found, well, that person's not conducting a business of their own. They're kind of a random casual labourer. They don't appear to be running their own business. But the court said, well, that's only one factor to consider, and we actually think that they're ultimately not an employee and they're a contractor when we look at all the factors surrounding the employment or the engagement. And so we have this decision sitting somewhat uneasily with the original authorities. And then we get to JAMSEC, where the opposite has been found, which is we had two truck drivers. They invested in their own vehicles.
So they own their own assets.
They own their own assets. They were responsible for the running costs, the repairs, the maintenance of those vehicles. They operated them in partnerships with their wives. They had tax invoices. They delivered the revenue through the partnership, paid tax as if they were
registered for GST.
All of that. Did that for 30 years. And the court accepted that they ran their own business, but actually found them to be employees. So again, these people were entrepreneurs in a sense, but simultaneously were employees of the principal. And so we've got both cases kind of just clashing up against the original authorities. And where we're actually getting to is that there are now High Court proceedings on foot with respect to both decisions. And I think what we're going to see is a level of clarity again about what the test is and how it operates. So where does that leave us with independent contracting? For many of you, you may have heard about the multi-factor test, which allows you to look at all sorts of factors. Does the person provide equipment? What level of control?
How are they paid?
Can they exercise over their work? How are they paid? Are they branded as if they're part of the business? To help you answer the ultimate question that's on that slide. That multi-factor test is still the test at the moment, but I think what we can expect is that right now, I'll tell you the position now is, even when you come to get advice, often there is an area of grey. You don't really know their status unless it's tested in court, unless it's arbitrated. I'm hoping that by the end of this year, once these cases...
Because JAMSEC's in the High Court.
They're both in the High Court.
Both in the High Court, yeah.
So, and they've both been listed together. And
now, we filed a brief in the JAMSEC matter.
So we are representing an organisation in that. And so I think there will be greater clarity. For now, there is uncertainty, but expect an area of improvement hopefully next year on some of that.
And probably the thing I would say to most people is this is an area you can get unstuck very quickly. I would urge you, this is one of those areas where I would say ringing early is better than ringing late. And look for the obvious areas that would cause us anxiety. If you're engaging somebody, all they have is an ABN. That's all they have. All they're providing is their labour. You're paying them by the hour. More often than not, you're in trouble. So just if you've got any anxiety about whether or not the person really is a contractor, please ring us right at the beginning rather than ring us at the end, because it'll save you a lot more money. I think that's the proposition. I thought it was a good explanation.
So I think the...
And do you think good sense will prevail?
Well, I think we need to be careful what we say, because we are actually involved in some of the proceedings. So we just say watch this space. But what I would say is, in relation to all of these forms of engagement before we leave it, you just need to work out what works best for your business. The disadvantage here is uncertainty at the moment. But in a year's time, there hopefully will be greater certainty. So just factor these things into your thinking when you think about how you're going to engage people. We've got a few questions, but we've got a little bit of time left to talk about the future world of work, which particularly this topic, Nigel, is one of considerable passion for you. We tend to agree on most things. We're slightly divergent on this one, although I actually think we agree on the outcomes. We have slightly different perspectives. Both.
I thought the only way to deal with this, because let's be honest, every time we talk to a client at the moment, even if it's not what they're talking to us about, they talk to us
there in the
about
list.
working from home, working in the office. It's impossible not to talk to somebody at the moment without talking about it. And I think when we were together last year, I said, be careful not to implement brand new hard and fast rules until we really get through COVID. And if that makes me sound like a bit of an old-fashioned person, I don't mind. I would still hold that view that you want to be quite cautious about cementing something in today. In a year's time, we'll probably have a great deal more understanding of where we are and what's working. And I pose this as questions because I don't necessarily suggest there's a perfect answer to any of these questions, but probably the first one is the really important one, which is ask yourself how you're describing what the default working environment is. We've got a lot of clients at the moment, and we started doing this ourselves. We started falling into the trap that perhaps the default was working from home and we hadn't actually agreed that yet. So the first question is your language setting up an outcome because you're talking about assuming that the default is working from home, and on that basis you're saying to people, we would like you to come back to the office 2 days a week. It does suggest that the home is the entitlement. Conversely, if you want to have a narrative that says the office is the default, well, we're happy to give you flexibility to do X days a week. So that's proposition number one. Work out why you're doing it is probably the thing I'd probably say. Is it about saving money? Is it about being more efficient? Is it about having a competitive employment offering? It's very clear to a lot of white-collar tech industries, if you don't offer the opportunity to work principally from home, I suspect in 3 years' time you won't even be in the ballpark for getting employees. In a lot of other industries, particularly blue-collar industries, it's still probably the opposite. The efficiency issue is a challenge, because we've got all sorts of mixed results on efficiency. We had people last year telling us they were more efficient. We're now seeing some people less efficient. Some people remain more efficient. I think it's a lot more complex than simply saying we didn't drop the ball with people working from home. You really have to analyse it. And then I'd probably say the other 2 or 3 things I'd probably add, really understand what's going on with your culture. Because I think a lot of businesses who do have people now principally as remote workers or working from home, they're starting to realise that culture's slipping, because culture involves connectivity. And I'm really, really sorry, I don't think you create necessary connectivity on Zoom. It's a great tool, but I'm not sure it's actually the way of building culture. And probably the one area which I think has worried me the most when I've talked to clients, and we've discussed this in our own business, is how effectively are you developing less experienced people in your business when you don't have day-to-day connectivity? And I'm very, very nervous at the moment, particularly in white-collar professional areas, about whether or not we're doing a disservice to that sort of 24 to 30-year-old bracket. They're not getting the day-to-day mentoring, the day-to-day guidance that perhaps you and I would have got in our career. So all I would say at the moment is, take those questions and think long and hard about where you sit in answering those questions before you jump into launching your new policy on the new way of working. Are there any of those which are bugging you in particular?
I've got 2 legal points that I think are important takeouts for our listeners or viewers. The first is, even if you are offering working from home, don't rush to change people's contracts in relation to this issue, because what you have at the moment in most contracts of employment is a work location that is specified at a particular office. So the location might be the Sydney office,
Chatswood office,
the factory here, the depot there. You have as a default position a contractual obligation to present for work at the office. What you might be doing at the moment is offering a temporary change to that, and I think that's how it should be expressed, so you can...
It's mutually agreeable.
They're mutually agreeable, but it's not an actual contractual change.
Yeah.
What you're saying is, we'll allow people to do this, we're going to keep reviewing it. That's how you can set it up. So that in a year's time, if it's not working for the business, you can say, well, we're no longer going to offer this. It's not, and it never became a contractual entitlement. Your contractual obligations to work from X. And that's an important thing to bear in mind. So I wouldn't go rushing to change people's contracts. The second thing to bear in mind is, many of our clients have started to implement a default working from home regime. It might be you can work from home 1 day a week. It might be you can work from home 2 days a week. But otherwise, you're expected to be in the office. So that's as people start to move to this hybrid method of working. The thing you need to bear in mind there is if you are putting in place a kind of rigid black and white regime, which a number of our clients have for varying reasons, don't lose sight of the fact that separately employees have a legal entitlement to request flexible working arrangements. Employees with particular attributes might have discrimination protections to seek to request particular types of working arrangements if they are otherwise unable to comply with your requirements. And so what that means is you can have your rigid approach, but you still need a process in place to effectively, a policy in place to effectively process requests for something different. If someone is a parent of a child under school age, or a parent of a person with a disability, or is over the age of 55, I think is the Fair Work Act provision, they have rights to request flexibility. You have to process that request through a particular regime. And for some of them, in certain limited circumstances, discrimination laws may have a role as well. So you need to ensure you have a proper regime in place for considering requests that might be for significantly greater hours at home.
And I think it's a really important issue because we had a client ring us last week, and I think what their psyche was, look, I've introduced this very flexible working from home policy. Surely that's I've done my bit.
Exactly.
I've done my bit, and I can't believe somebody's now asking for something in particular. And it was actually quite hard to get them psychologically over the hurdle that yes, you've done your bit, but that was something you wanted to do. You've still got to deal with their legal requests for flexible work arrangements.
Exactly. So you should have an established policy to set that up, and separately you can have your general approach communicated, whether it's by way of email or policy or otherwise. So we've got a couple of minutes left. We do have some questions. So we might should we go to a couple of questions?
I'm in your hands. You've got the prompter. I haven't today.
Okay. So one of the questions, I don't know if you should take this as a comment. The work at home versus in the office is really a bit of a nonsense for organisations like ours. You cannot make a fire truck at home. Cafes and hospitals, lots of us do not have this discussion. Any thoughts on that, Nigel?
Yeah, my answer would be unashamedly, thank you for that. That's entirely right. If I think about all of the people who we deal with who drive trucks, work in quarries, work in factories, this conversation almost hasn't even entered the psyche. They're continuing to work at their normal place of work. Those companies, when they talk to us, they're more challenged about what we might call their office workers, their white collar employees. That's another area where I would say tread carefully in the conversation, because it might not apply to any of your workforce, or you might be in a very difficult position where it can't apply to some of your workforce, but it might be able to apply to different parts of your workforce, and then you've got a cultural challenge of, well, why do they get that benefit and I don't? So I'm not. This is one of those rare occasions where I would say, if we advise somebody, I really want to understand where do you sit in that. I want to understand what sort of business you're running culturally, what sort of business it is, to arrive at some sort of sensible answer, which is that blend of culture, human resource management, operational practicality, and also the law. So yeah, absolutely. In fact, I was down at a quarry a couple of weeks ago, and I mentioned it, and I was looked at with disdain. It's like, well, mate, I've been at work for the last 18 months. Don't know what you're talking about. So yeah, I get that very much, and it's understandable.
Yeah. The next question, which I might take: what is the risk of engaging a person as a contractor if the test outcome is unclear and maybe an employee? Contractors also receive super, so what are the entitlements they're missing out on and therefore could request?
Well, let's take that in reverse. Some contractors get super.
If the engagement is principally for their labour. And so what we're talking about there is a sole trader, not a PTY limited entity, a sole trader that you engage principally for their time, their effort, their labour, their services. Even though they might genuinely be a contractor, they are still entitled to super under the broader definition.
Just unpack that, because that's really important. So if I'm operating through a PTY limited company, the answer would be no.
Yes, because the PTY limited company has the obligation to pay super.
That's fine. If I'm just turning up as Nigel with my ABN and I'm principally providing labour,
then super.
Even if I am a contractor, I still have to pay super.
Correct.
Yeah, and that's the
principal
one.
Still has
principal has to pay super, and that's the one people I think miss out on a lot. It's you do pay super for some independent contractors.
Yeah, that's right. And I mean, to answer the question about what else do we need to worry about, I mean, the real issue is if you have misrepresented the relationship, you probably haven't ever paid annual leave. That's the big one. So annual leave for, I mean, the Jamset case, it was 30 years. So 4 weeks times 30 years is 120 weeks.
They had long service leave as well.
Long service leave. There could be some sick leave type claim. It's probably less of an issue.
There could be a very difficult reconciliation about whether or not they were paid the award rate,
the hourly rates,
overtime, and
all of that. So it is a particular headache. But for all contractors, if you get it wrong, annual leave will be the absolute starting point.
Penalties?
Liability. There's two types of penalties. One is not for paying the annual leave, but secondly, if you've been reckless or deliberately misrepresented the nature of the relationship, you could have a sham contracting claim with penalties as well. So there's reasons to be cautious about it. Will slides of the presentation be provided via email after the seminar? It's a good question. We will be. We don't know the answer. I should check. Well, certainly there'll be a communication from our firm with a follow up, and if you're after them, you can certainly follow up with Fiona, who'll be responsible for that. There was a question as well as to whether there will be a recording available, and yes, there
is always a recording available. Yes.
There's another question about a non-profit organisation with the new casual employment law. It says small businesses less than 15 employees are not affected in this law. Is there a relief for a casual employee when it comes to counting employees? Now, what you're talking about there, which we actually didn't deal with for the purposes of today's discussion, is casual conversion.
Yeah, it's a different issue.
So in addition to the introduction of the definition of casual employment, there are new provisions requiring offers of casual conversion
to permanency.
To permanency after someone's been engaged for 12 months and after a level of regularity and systematic engagement. Now, the obligation to offer, I think, does arise with respect to employers greater than 15 employees. I think there are some technical differences about whether it's an offer or a request below 15, and that's certainly something I'd encourage you to reach out and we can give you the specific advice on. But yes, it's a helpful reminder that for our viewers watching, in addition to the new definitions, there is now an obligation to convert casuals after 12 months of engagement, if they've been regular and systematic, unless there's reasonable grounds to not do so. And that's something that's probably going to feed into your selection process, so it's a helpful reminder.
And we've got 1 minute left, so I'm going to do this in a minute.
Okay.
Are you ready?
Yep.
I just want to do this in a minute. So look, there'll be a lot over the next 5 years. There's going to be a lot in this space about how people are defined, how they're classified, how we employ them. I suspect there's going to be a big debate about what we call dependent contractors versus truly independent contractors. That is an American definition. I know that the Labor Party and the Liberal Party in Australia don't like it, but don't be shocked if we end up with two classes of independent contractor. I suspect there's going to be ongoing pressure in Australia about these payment schemes where instead of giving somebody sick leave or whatever, it's all paid into a national scheme. I suspect if we had a Labor Party win the next election, that'll be a platform that they'll come in on, and that'll be a big cost issue for employers because things like sick leave, there's no provision set aside in their accounts for things like sick leave, so if all of a sudden I'm having to pay into a scheme, that'll be a big issue. And sourcing platforms, Uber, I'm not an Uber Eats guy, I know you occasionally can be, you're younger than me. We've just had a decision which said, it was Deliveroo, that their drivers are, their motorbike people are employees. I suspect that'll be appealed.
Yeah.
But I would think, tell me if you disagree, I would think over the next couple of years, we're going to have this ongoing debate about where do these platform services fit in? Are they independent contractors? Are they employees? Or as some of the platforms argue, there's something in the mist in the middle.
And I think my 2 cents worth, we can fast forward 2 years and see if it's right. So hopefully this is kept somewhere. My 2 cents worth is they ultimately might remain non-employees, whether they're dependent.
But they're going to get regulated.
But they're going to get a level of regulation. The things people are worried about, insurance for injury, so workers' comp type insurance.
Earning the minimum hourly rate.
A minimum rate potentially of some kind.
Yeah.
And potentially an ability to be sick and have some coverage, particularly since the pandemic's arrived.
Yeah.
So I think we won't see employment type entitlements except for 2 or 3 key areas. And that's where we'll probably end up, a more streamlined set of regulation for a broader class of worker. That's probably where we will eventually end up, but it might take 5 years to get there.
We'll watch that space. And we'll let you know as things develop. We'll let you know, as we always do. Thanks for coming along today. Thanks for being with us. We jumped aggressively from the HR side to the sort of more legal side. A little bit of conversation there about the future of work going forward. As always, mate, it's been a pleasure. It's been fun. I said to Lewis, it's our first winter one.
That's right.
Next time, I wonder whether or not we could actually do it in front of a fireplace. I'm not really sure if we'd get away with that. But stay well. If you want to follow up with us, please drop us a line, give us a call. I think we have a. Do we have a? No, we don't. We don't have a slide saying how you contact us. But
we'll email out anyway.
Please, we'll email out to you. Take care. Stay safe, and hopefully, in the not too distant future, the pandemic will be finished, and we will be back to some semblance of normal. So, thanks for staying with us today. Take care.